All right, for the third week in a row, we are fortunate to have Peter Tragos, lawyer joining us to talk the Karen Reed case. And Peter, we were just talking before we started recording. I was kind of interested, you're a lawyer, you have a firm. How do you juggle your streaming and following a case as close as you do with your practice?
Yeah, I mean it seems like a lot if you look at it from the outside, but I have a lot of help from a lot of people that work at the firm. I really enjoy it, but my calendar is something I have to stick to every single day. And I used to listen to a bunch of sports podcasts, fantasy football, college football, and now I pretty much only listen to trials. So I've gotten a lot worse at all of that because I'm listening to so many of these cases and hearings and things going on in the true crime world. The 2.5 times speed on YouTube is amazing. So at lunch, I can listen to 2.5 hours later in the afternoon. So basically, it takes me maybe 2 or 3 hours of listening as if it were a podcast on 2.5 times speed.
All right, so I was on the alternate list. So as you know,
Okay.
the court system is set up. There's so many people who want to get into the trial. There's only like 10
Yeah.
seats for reporters. It's called the randomizer. I call it the Danielizer because I haven't been super successful in getting in, but I was an alternate this week and I actually got in every day. Court ended for the week Wednesday. The judge actually said things were moving ahead of schedule, which, surprised us all because that certainly didn't happen in the first trial. We felt like we were always trying to catch up. And Karen Reed at least said that prosecution only has one more witness to go. So a much
Oh,
more packaged case from Hank Brennan than we got the first time around from Adam Lowy, who went through, just witness after witness who may have not even had, sort of a direct correlation to the events.
yeah. I didn't know that there was only one witness left. I would assume that's Dr. Welcher, obviously the accident reconstructionist, who may take a couple days. But that would mean the Commonwealth's going to be done next week. That also makes sense. I saw some people watching getting frustrated that, we're ahead of schedule. Why can't we just keep going? Why do we have to stop or get back on schedule just because we're ahead of schedule? When it comes to experts like Dr. Isaac, like Welcher, like Burgess, even, they have to be scheduled ahead of time. So if Welcher was planning on being here Tuesday, just because they finished on Wednesday doesn't mean he's going to show up on Thursday. It's just not how it works. That's why we said forget it with as the trial goes. That's why Judge Cannone said forget it on Thursday. We weren't planning on being in on Friday. Monday is a holiday. So Welcher was supposed to come Tuesday. Welcher's going to come Tuesday. And that's what's going to happen. That's why it seems like we're wasting a couple days. But really, it's because you couldn't just get him to shift in there as if he's a lay witness, as if he's a law enforcement witness who can just come show up to the courthouse whenever you need him.
Let's talk about sort of the drama that happened yesterday. All of a sudden, the court starts a little bit later. They've been really good about starting a little after 9. Yesterday didn't start till 9:30 or so. First thing Cannone says out of the gate is, "Hey, I got to talk to every juror individually." Shuts the camera off. Everyone gets kicked out of the courtroom. The courtroom's on the second floor. You couldn't even hang out on the second floor. They wanted everyone downstairs. But an hour later, all 18 jurors come filing back in. So nobody got kicked off. I asked Karen, "Hey, what was the deal with that?" She said she couldn't say, other than these kind of things happen. What's your take of what likely happened that would cause Judge Cannone to want to speak to all the jurors?
If you remember from the first trial, or if you followed the Murdoch trial at all, in such a high profile case, we have heard jurors inadvertently seeing things, hearing things, being told things outside the courtroom. It could be on social media. It could be you on TV. It could be, some other local channel where somebody's talking about something, jurors walking by, jurors at dinner, getting lunch on the weekend at a sports bar, and it comes up on the TV and they see something. And maybe they let the court know. It could be a juror just happens to be talkative and during lunch breaks or something like that, they mention something about the case that they shouldn't. And another juror that's more sensitive brings it to the court or the bailiff or somebody's attention. Hey, somebody's talking about this case. It didn't seem like it was egregious or it rose to the level of somebody needing to be struck. But many times a judge will want to talk to every single juror to say, did you see that? Did you hear that? Is it affecting you? Has that juror said stuff to you before? If it's an individual juror issue, and it seems like she was able to talk to every juror, neither side, actually, we don't know if either side really pushed for one of these jurors to get struck. We also don't know, because a lot of times when you get information like this, as a lawyer or as a party like Karen Reed, you can start to get an understanding. That juror that said X, Y, or Z, are they good for me? Are they bad for me? If they're bad for me, I'm going to try to say that's prejudicial. We need to get them off. Or the Commonwealth, we need to get them off. If it's good for me, you fight to keep them on. If it's neutral, it's usually a pretty easy discussion, Judge. Let's just keep them on. But there can be discussions about saying maybe we can make that person an alternate if we don't need them, depending on what they said or did.
So the jury spends a lot of time together. They meet in a parking lot. They take a coach bus to court. They have lunch together. Then they'll head back. Are they allowed to discuss it all amongst themselves, just sort of privately, sort of what they've heard so far, and not necessarily giving an opinion, but let's say, hey, I have in my notes that this person said this. Do you have that? Or can they do that?
No, they can discuss what they had for lunch, what their kid does, what school their kids go to, what they do for extracurricular activities. They cannot discuss the case. They can't discuss the facts. Did you get this? Did you get that? What did you think of that witness? Oh, I went to the same college. I know that degree doesn't exist. Whatever
Okay.
it may be, they cannot talk about that kind of thing that will have any effect on how they see the case. It's supposed to be completely independent, which the Delphi case, Richard Allen, they were allowed to discuss the trial. That's the first I've ever heard of a jurisdiction doing that. I've never practiced in a jurisdiction or tried a case in a jurisdiction where they're allowed to discuss it at all.
All right, you did the perfect segue to degrees in education. Shannon Burgess from the firm Aperture, prosecution witness. He analyzed events in Karen Reed's car, sort of from the black box, the text stream data, and events on John O'Keefe's phone. And what his conclusion was that Karen Reed made a 3-point turn, then she drove in reverse based on what the Lexus data revealed. And that the whole sort of key, and it took hours to get there, and so much technical stuff that you got to wonder if it goes over the jury's head. But the whole key of his testimony was him saying that that event with Karen reversing matches the time of John's last interaction with his iPhone. You think the jury got that?
I think some of them probably did. I think, as with a few of the Commonwealth witnesses, you can see where they're trying to go. You can see what they're trying to set up with their timeline. It can get kind of confusing in the details, but I think overall there are probably some jurors that did get that from his direct. And I do think that can be compelling. You're setting up the timeline. We heard trial one juror say Karen was there, Carr was there, John was there, everybody was drunk. So we can see how this accident happened. Well, now if you add a few elements to that, John's phone was there at this time. Karen Reed's car was there and backed up at 24. He didn't really say the miles per hour, but I assume we're going to get that.
Yep.
Her car backed up at this time, right about the same time, with a little clock variance of when his phone stopped moving and working forever for the rest of his life. I think that can be compelling to some of the jurors sitting there who are looking on how to piece this together. How's the Commonwealth going to piece this together? And that can be very important building blocks.
But of course, this all comes in a new report that the defense says was not dropped on them until May 11th, and that Burgess just said all I did was sync the times up between the phone and the Lexus because they're off by like 20 seconds or so. And that was a huge issue for the defense. They actually tried to keep that testimony out. Judge Cannoni sided with the prosecution, said no, it is coming in. Outside of court, after Shannon Burgess finished, Karen Reed said, okay, yeah, that timeline is junk because we have John O'Keefe still moving or his phone still active after. One of the things that Brennan did was immediately after Shannon Burgess' testimony, where he gave these times, he showed a video from the ID Max interview that Karen Reed did from that series that aired. I asked her after court, I said, like, how do you know then? How did you know when John died?
Interview, how did you come up with that time yourself?
That 12:25 time.
And that was based on phone data that we have that everyone has seen now.
I mean, I don't really think any of the comments she's made on any of these interviews have helped her. The prosecution's the one playing them and picking which ones to clip and putting them in their series of the case and where they think the context helps them the most. So you're going to assume they're going to be better for the prosecution. And that's what I think most of the clips have been. I think there are aspects of them that can help the defense as well, where she's just wrong. And frankly, if I was her, I would think maybe I thought it was 12:25 or 12:30 because that's when I had left. because that's the only way I can get back to his house by 12:36. I would have had to leave before 12:30 because it takes me more than 6 minutes to get home. Those are the types of things that I think we haven't heard a lot from the timeline. I think the Commonwealth has done their job and try to make the timeline fit what they say the data says, which is what they said they're going to do in opening statements, which is why it was such a big deal that Shannon Burgess changed his report. And I think that is a judge question. And the reason it's a judge question as to whether or not to allow him to do that is the sting is never as much to the jury when they hear, you did an updated report in the middle of trial. We weren't able to react to this. We may know how it feels as a lawyer and as a judge and people following the case. The jury may be like, what's the big deal? He told you before he testified. It's just a clock variance. I don't see the big deal. When in this case, minutes and seconds can be incredibly important.
And I was really impressed with Bob Alessi with his cross of Shannon Burgess. Bob just has a way of he's sort of subtle, but he definitely hits his points. He certainly seems like a seasoned defense trial attorney.
Absolutely. And he's methodical. He doesn't care if the judge rushes him. He doesn't care if people like his style. He's going to do it the way he knows how to do it. And he's a great example of don't try to emulate somebody. Be yourself. Be the best version of yourself. I could never be like Bob Alessi. Bob Alessi could never be like Alan Jackson. Alan Jackson can never be like David Yannetti. You got to take your own personality, your own flavor, the way you do it, perfect it, be prepared, work hard, and it can be incredibly effective. You can see there's not just one way to skin a cat, as they say, as a lawyer. There are different ways to be extremely effective as a trial lawyer.
And one of the things that Alessi was very effective at was questioning Burgess's credentials. The issue was that his LinkedIn and some of the profiles that he had talking about his education showed a bachelor's degree that he's never actually obtained. Do you think some of the jurors, once they heard that, immediately said, all right, I can't really, I might have to take his testimony with a grain of salt based on that?
I think there's probably jurors in different buckets. There's probably some jurors that thought exactly what you said. Forget this guy. How could you lie about that? Some jurors that think, well, you shouldn't even be able to be an expert without a bachelor's degree, which is not true. But because it was highlighted so much in this, and because of his discrepancies and inaccuracies that he had to put on LinkedIn or his resumes, I think there will be some jurors there. I think there will be some jurors that think, oh, whatever, Bob Alessi was mean. I've had cases where we thought we destroyed experts. Some jurors thought, wow, I couldn't believe anything that expert said. And other jurors were like, I felt bad for him. He's just trying to do his job. And then there will be jurors that I think will wait and say, like you said, maybe with a grain of salt, let's compare that with the defense expert. If they're more reliable, they're more credible, they're more educated, maybe I'll believe what they say over what Mr. Burgess says.
Yeah. And, Burgess never seemed to, we've seen other witnesses almost get sort of hostile. He never did that. He kind of kept his cool. But Alessi was just really good about hitting that point. It's like there's multiple ways to attack something. He attacked it from every way possible, so it hits home. He wanted that to stick with the jury, that there were issues. And what Burgess said was, hey, I'm not even submitting this stuff. This is all my company. And they're the ones who incorrectly listed a degree I had. But to me, that just seems like common sense 101. Like, you can't have, that's a loose end, right? You can't have that loose end if you're testifying in the biggest murder trial in the country.
I actually thought his testimony was pretty good for the Commonwealth compared to a lot of their witnesses. He was lining that timeline up. He explained away the time discrepancy that I thought was going to be a big deal. I thought he did a pretty good job with that if it wasn't for that huge credibility issue, I thought he could have been a really good witness for the Commonwealth. But if I was on the jury, I'd be like, wow, that is insane that this guy would do something like that. It's like diabolical that he would do something like that, outfacing to clients trying to hire him. I know what I would think the reasons are that he did that, and that would really crush his credibility and reliability. And when the lawyers in closing arguments say, hey, we have a jury instruction. If you don't find a witness credible or reliable, you can throw out everything they say. I might think of Mr. Burgess when they said that.
Okay. On Monday, DNA was sort of the focus. You had two scientists from Bodie Labs. It's a private firm that the Commonwealth hired to analyze DNA. Nicholas Bradford was one of those experts. He said that his testing showed that DNA belonging to O'Keefe and two others was found on Reed's taillight. So the question is, okay, how does John O'Keefe's DNA get there? And I think the defense certainly tried to say, well, he's around this, he's around this car all the time. He's been dating Karen for years now. Of course he might get out of the car and walk by it.
So we'll start with the DNA. And I think that there's some people in my chats when I do videos that think that's a really big factor. How did his DNA get on the taillight? It just happened to be on the taillight. Now, they didn't test the entire car and the handles and the doors. Was his DNA all over the car? I think if it was, that would make this less significant. And I think the defense pointed that out. But I also think, again, if you're checking boxes at the Commonwealth and you want people to think that taillight hit John O'Keefe, this was a step in that direction. It's all going to culminate and come down to what Welcher can prove as far as the car hitting John O'Keefe and what we have to prove that with the science and the mathematics. And I think this was a step in that direction, but I think it really is all going to come down to Welcher.
And Welcher, it's my understanding, he is replacing Trooper Paul. So Trooper Paul testified in the first trial, and I think a lot of people remember his testimony. He appeared to struggle with some of the evidence and information that he was given.
Yeah, Trooper Paul really seemed like a nice enough guy, but he was horrible.
Yep.
I mean, there's no way around it. He was a horrible witness, horrible expert witness, would say stuff like, it was speaking to me. I don't know how the evidence got there. I didn't put it there. Way too many either I don't notes or
it is what it is.
Logically impossible to believe. It really couldn't get worse than that. He was one of the key factors in how I looked at the first trial, especially in comparison with ARCA. I expect it to be very different with Dr. Welcher. And that's why you got to stay open to what is this jury only watching this trial going to say, because it may be different than people that have been following it for years.
And you talked about the hair, the traveling hair on the right rear quarter panel, a single piece of hair. We've seen multiple pictures of it. They're saying that was also a match for John O'Keefe and two other people. I think if I'm correct, so
I think with the hair, it was they couldn't exclude the maternal side of John O'Keefe's family. So it was almost seemed like it was just as likely to be John O'Keefe, his niece, his nephew, his mom, everybody on that side of the family potentially, which the defense did a good job to highlight. But again, I think if you're the jury and you're trying to piece this together, that can help you say, oh, his hair ended up there. It felt a little to me like, I don't know if you've ever seen Four Brothers, where at the end of the movie, they're interrogating each one and they're holding up the hair. We're like, we got your hair. And he's like, that's not my hair, man. You could easily plant that. And, that's like a thing that, people say about cops, the magical hair that stayed on there somehow, some way through the winds and the storms and the snowstorm and getting on the tow truck and driving back from Fairview to Meadows to Guyton to Canton. It's like, how did that one hair stay on there? And then it started moving right as they're taking the picture. If I was a juror, that wouldn't be a big deal to me because, I don't really get how that hair stayed. But if you're looking to check the boxes and move it along, I think the Commonwealth at least got out that it could not be excluded as John O'Keefe's hair.
So when we get to, it looks like now that the defense will probably start. I'm assuming Welcher's probably going to be on the stand for a couple days. I don't see how he's not a power player for the prosecution, and I think the defense is going to, grill his conclusions and really try to discredit him and his findings. So then we get to the defense's case. Don't know exactly how many witnesses they are going to call, but my understanding it's probably going to be a few more than we saw in the first trial.
I would say ARCA is number one. ARCA's always been number one to me. But Proctor, I get what you're saying as far as lay witnesses go and just crushing the Commonwealth's case. Very important.
Yeah. And then ARCA, those are the scientists who are hired by the FBI, and they concluded no way, no how that this was not a car strike, that the science simply does not add up. And they are extremely poised and well-spoken witnesses.
And I think they are going to be significantly more defense friendly this time than they were the first time. The first time they were still under contract potentially with the DOJ. They weren't defense experts. They were just, we're unbiased witnesses here. They've gotten a lot of attacks from Hank Brennan, from the Commonwealth, from some people on that side. I think they are going to this is going to be something they're going to want to shine in. And I think that they will be even better for the defense this time around. We've got Dr. Russell, the dog bite expert, slash, I think she's a car accident injury expert as well. You have the medical examiner on the defense side. You have DeSorga, who's going to be the data tech guy for them. Potentially Richard Green, who's going to talk about Google searches. You've got a lot of witnesses. And Karen Reed said on the courthouse steps, there's going to be a more robust defense case this time than trial number one. And that's exactly what I expect.
Right, because it was we've talked before. It was my impression that they thought they had a lock, that it was a slam dunk, that they didn't really have to do much to get a not guilty verdict, and that wasn't actually what happened. It turned out to be a mistrial. Peter, I really appreciate coming on again. This is such a great opportunity for me because I feel like you have such a good knowledge of this case, and it's great for our viewers to hear your thoughts. I know you have a huge audience that follows you through the trial, and I've been enjoying your videos as well. So thank you again for coming on with us. Anything to look out for, final thoughts as we head into the final week of the prosecution's case?
Yeah, I mean, I've really enjoyed talking to you about it too. I think it's a really cool perspective. Somebody locally, somebody that's literally in the courtroom. Like I said, I always read your tweets to follow anything to try to get what is actually going on. What can we find out? Quotes from Karen Reed. I really think we are not done. The Commonwealth is going to close their case in chief. And after last trial, the trial was almost done when that happened. I think we're going to have a robust defense case. And then I think we're going to have a much larger rebuttal than we may expect, because he's going to be able to split Welcher's testimony. He's going to rebut the dog bite expert. I think Hank Brennan is saving some for rebuttal in this case to have the last word in front of the jury. And then will the defense fight for a surrebuttal because of all the things that are happening in this case? So it is not over just because the Commonwealth closes their case in chief. So everybody be ready for that.
Awesome. All right. Big week ahead next week, and hopefully we'll catch you again then at the end of next week, and we'll wrap it all up. But Peter Tragos, he is lawyer, on all social media platforms, and he does breakdowns of the case. He's posting about it all the time. He's an excellent follow, and we appreciate you taking the time with us.
Thanks for having me.
All right. Take care.